Oh, hi. I forgot we're starting. One of those days. Wow. How's everybody doing? I've been chatting for like 20 minutes and I'm not even paying attention that I'm actually starting the stream right now. I'm acting like I'm watching the stream. It happens. Who knows? That's the problem with being a viewer as well as a streamer all at the same time. You kind of lose track of which one you're doing at which time. Today we've got a really good show. We're starting off with Fleischer. A lot of us were there to see Fleischer yesterday. I didn't get to see a lot of the stuff that happened live, but I grabbed about an hour's worth of what I thought was really good stuff from the Fleischer set yesterday. Then I have a really cool set of cases with Magistrate Burton. And then at the last part of the stream here, we're going to end it up with Manning, and between Burton and Manning, I have a little bit of an announcement I'd like to make. But before we do any of that, we're going to watch Judge Fleischer. So, let's not mess around. Let's go ahead and get started, shall we? Ladies and gentlemen, I present to you Judge Fleischer from yesterday, Friday, July 19th. I don't know why whatever. Y'all, good morning. Happy Saturday. Hope everybody's having a great week.
Victoria, who is this?
Page 1, Robinson.
Got it. So how many times does this dude evaded us?
There were 2 PR bonds posted. This is the second one.
Yeah, I'm not done with him getting multiple PR bonds like that.
Hold on.
Case is 351 days old. You get PR bond after PR bond. I don't think so, Mr. Robinson. No, I will appoint you a lawyer today. He goes with you. Can you please appoint him someone and then we'll talk? But ma'am, don't send him down. Yeah.
Page 1, Applegate.
Don't send him down though. Yeah, thanks. Good morning, Mr. Applegate. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On July 13th, 2024, officers conducting routine business checks due to burglaries because of lack of electricity because of Hurricane Beryl. Officers checked out on a suspicious male at a Goodwill that was closed at the time. The defendant was observed by the officers to be placing items in his vehicle. They made contact with the defendant and conducted a Terry frisk, which discovered 2.6 grams of marijuana. The defendant said he was picking up scrap metal from outside the location, and the defendant had a felony warrant for burglary of a building.
Okay, so this isn't, because I see that he's got an open burglary of a building. This is, don't say anything. I don't need your help.
It's unrelated. It's a separate transaction.
So I guess they didn't charge him with anything as far as their.
Correct. The
concerned.
burglary of a building was April of last year, and he was on the warrant for that case at the time. He's posted bond.
So where was the weed in his pocket?
Correct. In his pocket.
Can you tell me about the burglary of the building, please?
Good, 2023, 7110 Barker Cypress Road. Responded to Rainforest Car Wash, spoke with the manager, said the defendant was a former employee, had broken into the business and stole vacuum and buffer. Victim said the defendant came back and asked for his job back. Manager showed business surveillance to the police of the defendant pulling up in his Lincoln Navigator, forcing his way into the business and taking the property.
Mr. Applegate, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or dope, I will put you in jail, and I'm going to make your bond extremely high. Do you understand? My sole purpose in life is to protect every single person and every single piece of property in Harris County. If I find that you act like a fool while you're out there in the free world, I will take it away from you in a heartbeat. Do you understand? I don't care what you're doing. I don't care where you're going. I don't care who you're with. You endanger my property. You endanger my public. I'm gonna light you up. Do you understand? What do you do for a living?
I'm unemployed right now. Right now, I'm just gonna clean up, like cutting the trees down and everything like that because of the storms.
Do you have a full-time job? It's time for you to get a full-time job. You have way too much time on your hands and you are becoming self-destructive. All you're doing is you're picking up more cases, doing stuff you shouldn't be doing. Do you understand? I will appoint you a lawyer today. I'm gonna bring you back in 2 weeks and I wanna see what you have done to get a full-time job. If you've done nothing, it's just not gonna go well for you. Do you understand me? I don't know if there's an application on file or not. Deeps is not working again. For now, I'm gonna have you go to Victoria, sign a reset. After that, I'm gonna have you take a seat in the jury box while I find you a lawyer. After that, you're gonna meet with Tracy for your bond conditions. You are now on notice. I'm telling you, if you don't have anyone to pony up a $10,000 to $15,000 bond on you, you will be stuck like Chuck in jail until this case is over with. Behave yourself. Do you understand? All right.
Right this way. Judge, that was 2 weeks to get a job?
Yeah.
State
Well,
bond?
to see what he's done to get a job. Be back here in 2 weeks.
State's bond conditions?
No, with Tracy. Make sure that he's not using. Hi. Do you have an arraignment? Okay,
Last name is Moore.
okay. Mind bringing him up?
What's the last name?
Moore.
Judge, there was a co-defendant on this one, page 11. Is it that one?
Yeah, you should have.
Robert Moore, come up. And
Sorry.
Victoria, who is the co-defendant?
Jones, but it wound up in felony point.
I think the last name is Owen.
Kevin Owens.
I saw Jones on the information. Sorry, how you said it.
You're not going to be happy with me after this is over with, Mr. Moore. I'm going to tell you that. You're laughing and smiling now. You now picked up. You picked up a new case while you're on bond. You now are charged with possession of marijuana. And as I can see, this is your 1, 2, 3, 4, 5th marijuana case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On July 13th, 2024, officers conducted a traffic stop at approximately 1:49 a.m. on a blue Charger parked on the side of the road with multiple individuals hanging around the vehicle. And the vehicle also drove off and failed to signal while making a right turn. The driver was ID'd as Robert Moore. The passenger was ID'd as Kevin Owens. Officers observed a strong odor of marijuana from the vehicle. A large bag was in the back seat containing multiple prepackaged marijuana baggies. Neither defendants claimed ownership of the baggies, and the total weight was 22.1 grams.
So what were they doing?
They were on the side of the road, hanging outside of the vehicle, and then they drove off and failed to signal while making a right turn.
Okay, so that's what led the cops led them to pull them over. Mr. Moore,
Yes, sir.
I'm gonna find that there's probable cause to go forward with your case. What is the one thing I asked you not to do?
Catch another case.
What did you do?
Catch a case.
Guess what happens now? He goes with you. Sorry, man.
Your Honor, is it, can we approach the court right now asking for a bond?
Yeah, I mean, of course, I'm gonna send him a bond.
And even in regards to, I know it's a couple of cross hearings, but I know they're saying that he made a right turn, we're still waiting for dash cam, but the biggest issue that they were saying was that the gas station he was at is a high crime area.
I
And
don't
that's
care
the
about
biggest
that.
thing, was just him having people around the vehicle.
I mean, ultimately, they pull him over. He's slinging, you know what I mean? So I'm not happy. And it's his fifth weed case. It's over and over and over, and he's not getting it. So what do we do to get him to get it? You know, I don't know.
And I will say, I know that there's been a gap in time, like I think his last charge he had was from 2018 and then just had these recent two. And I think the biggest thing is just the company that he's keeping. And we talked about that before. I just was recently returned.
I get it. And so what we'll do is that once he gets out, we will try to, well, not try to, I'll make it a condition that he's not to hang around with any of the
Okay.
co-defendants or anything like that. And we'll see. Hopefully he can abide.
And I told the court will provide I know it says the defendant didn't take ownership, but the other defendant Owens has. And so I'm just waiting to get that from the court, so that he was taking ownership of the drugs that were in the vehicle.
Okay.
So I'll get that to the court.
So what did he get? What did the co-defendant get charged with?
Possession of marijuana, 4 ounces to 5 pounds.
Hmm.
It's in the 182nd.
Okay. All right. Well, I guess so what's gonna happen is he'll pop back up on Monday's docket. I'm assuming he's gonna bond out because I'm not making it super high. If he is still if he hasn't bonded out, he'll be here Monday morning. If not, he'll be here in a week and we'll probably see him next Friday. Yeah, thanks. 5,001. Yeah.
5,001.
One, yeah, on the UCW, please.
On the UCW.
Just on the UCW, correct. I will leave the first bond for the week kids. I'll leave it alone. Okay, thanks. Sorry.
No problem, I understand. You do your job.
Judge, page 6. Henderson, come on up.
You Kenneth Henderson. Mr. Henderson, you're charged with failure to identify oneself. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford one, one will be appointed to you, sir. Okay.
On July 11, 2024, officers were dispatched to an assault in progress call at a park. When they arrived, the two parties matching the description were already walking away. Officers approached the defendant, who provided his name, Kenan Henderson, 6206, date of birth. Officers were unable to get a hit and asked him to re-verify. The defendant stated.
Again, what's he doing wrong at the park?
There was an assault, Your Honor.
Oh, there was an assault.
There was an assault call in progress, and the defendant
Oh.
and the other party matched the description.
Got it. Okay.
Officers were unable to get a hit and asked him to re-verify. The defendant stated it was correct and that he was 18 and never had a TCID and a a Texas ID and did not know his social security number. He got upset and stated he wasn't lying. The defendant gave his mother's phone number to verify, and she gave the true information. The defendant gave a false date of birth and concealed that he was 21 years old, dating a 16-year-old.
So the information he gave was just the wrong date of birth? What happened with the assault investigation? Was there an actual assault?
That's what they were discussed, Judge. I'll have to do some follow-up, but we didn't charge him with an assault or anybody else. from what I see.
And so you're saying that in the call for the assault, he matched the description?
That is correct, Judge. That's what's being alleged. I think.
All right. Mr. Henderson, I'm going to find that there's probable cause to go forward with your case. So you're 18, correct? Or how, are you 19? How old are you?
21.
What do you do for a living? Nothing?
NRZ, with Andy Fern.
Did you graduate from high school? Why not?
Medical.
What grade did you make it to?
12. 12.
I mean, you're almost there. Why didn't you follow through, man? You just dropped out on the last year. Why? It's time for you to go back. And I want to see you go back. And I am now making that a condition of your bond that you and I together are going to try to get your GED. You cannot roll around life with, at the very minimum, a high school diploma. You will go nowhere. You will make pennies on the dollar for the rest of your life. This life is a journey, and it can be a great journey, or it could be an absolute miserable, rotten toilet of an existence. And I'm going to tell you, if you have no money, it's going to be a rotten life, because you need money for everything in life. And if you don't have money, you'll never get a car. You'll never go on a vacation. You want to get a wife one day? You want to keep that wife? If you ain't got no money, all you're going to do is fight. It's a miserable, rotten existence. And it starts with getting, at the minimum, your high school diploma. So I will give you a lawyer today. In 2 weeks, I want you back here to show me what you have done to start looking about getting into GED classes. I have the lawyer who has resources to also help you out so that we can give you money, we can give you computers, whatever you need. But it starts with you. Do you understand? I'm telling you, life sucks without money. It's really real. Everyone wants to see you fail. Everyone laughs when you fall down. Don't give them a reason. And it starts with your high school diploma. You understand? No smoking any dope. I'm going to test you. I will test you 31 days from today. If I see that you're smoking dope, then you will get your GED with me behind bars. You understand? Okay? I'm not asking for much. Make me proud. All right. Can you reach out to the MAC for him, and then we'll see him back in 2 weeks, see what he's done? Okay. Mr. Henderson, I'm going to have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we start on all the paperwork for you.
Three co-defendants. First one is page 8, Jackson. Real. And then page 11, Odom, come on up. And then page 17, Thomas, come on up.
Gonzalez Jennifer.
Okay,
All right, Judge, page 8, Jackson, page 11, Odom, page 17, Thomas.
all of you are charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 11th, 2024, officers conducted a traffic stop on a vehicle for failing to come to a complete stop at a four-way intersection with all the traffic lights off. The driver quickly exited the vehicle and was detained and ID'd as defendant Alexis. Defendant Odom exited the passenger side and started walking away and was detained. The defendant Thomas got out of the back driver's side door, and defendant Jackson was in the back passenger side door. There was a Glock in the driver's side floorboard, unholstered, round in the chamber within arm span of defendant Alexis, who is 20. And defendant Odom had a backpack on and it was open and a baggie of marijuana was visible. 51 grams of marijuana was recovered, an electric scale and a Glock was in Odom's backpack. Defendant Thomas had 7.23 grams of marijuana tucked in her bra. Defendant Jackson's purse smelled of marijuana and 4.88 grams of marijuana was in the purse.
Who's the driver?
It says defendant Alexis, but
Defendant Alexis is in court at 3, Your Honor. For whatever reason.
So there's a fourth.
there's a four.
What's the cause number, please?
251-9367.
That's the earliest cause number.
So they may all know.
You gonna do that now?
I can, I'll take a seat after we judge.
Okay. Here's the deal. You guys are all getting transferred to court 3 because they've got the lowest cause number. We're gonna do the transfer order here momentarily. I'm gonna sign it and then we're gonna send you all to court 3. So if you just mind just taking a seat over there, we'll be back with you momentarily. Do not leave, guys.
All right, Judge, page 9, Johnson. There's a co-defendant on this one, last name Williams. That one landed in court 3, but should come.
What page was it?
Page 9.
Okay. Are you Patricia Johnson? Ms. Johnson, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, ma'am. Okay.
On July 13th, 2024, officers received credible information from a concerned citizen that the co-defendant, a currently wanted person in Harris County, Texas for felony family assault, was inside a residence located at 710 West Bluff Drive in the garage portion of the residence. After opening the garage of the residence, officers observed the defendant lying in bed next to the defendant. As officers began to call the defendant and co-defendant out of the garage, officers observed several items of drug paraphernalia, such as used glass pipes and a white powdery substance wrapped in a clear plastic bag. Through further investigation, deputies observed 1.5 grams of marijuana located underneath the white powdery substance. And at the time of the incident, it was unclear what the substance was, but neither the defendant or co-defendant claimed ownership of the substance that had an approximate weight of 2 grams.
So how do you know it's hers? She's just at the house, right?
Right, Your Honor.
Is it her house?
It's unclear whose house it was. It's
Patricia Johnson. Ms. Johnson, just take a seat for me in the jury box. I'll be back with you here momentarily. I need to do a deeper dive on your case. You can get your stuff. So Williams is upstairs though, right? Ma'am, take a seat for me at the jury box.
Is in court 3.
Oh, that's, he got a weed case too.
You got, yes, yeah,
Okay.
and we have the lowest.
Ma'am, don't say anything, please. Next. Yeah.
Thank you.
Hi.
Good morning, Judge.
Good morning.
On Mr. Robinson.
Okay,
Approach it,
okay.
cautiously. Mr. Robinson is a normal liver, not yet. Judge, he has provided me the last contact he had with this lawyer. He did not have an easy time. He left the court with this reset in hand that told him he did not need to appear on December 5th and went home to his house, which was completely boarded up and eviction notices posted. He was completely unable to get in his home and then picked up the new case because he called the police and made the report trying to get into his home. So he has had quite a bout of bad luck. I've spoken with the state about the offer. He never obtained that offer from his previous counsel
That's
because
so not true, because we spoke about it with him, you know, and we spoke to him on December 5th. Discovery was complete. Admonished him that he had a 2-hour class or 2 hours of community service and a class to do for dismissal.
Oh, so he was admonished in court. He did not
We,
explain that to
like,
me,
we do
right?
that with every single person,
Okay,
ever, because we let them know, hey,
sure.
no, your case is getting old. It's time for you to get it done.
Well, he did leave court to a locked up, boarded up house, and he has since been able to get on his feet. He has obtained a job. He has a very limited financial situation because he has 7 children he's supporting. The state graciously upped the offer a little bit. They would reinstate that, and we would take that PTI offer today if the court would consider it. He understands this case is old and that you would be making a special exception, Your Honor. Not to reward him for not showing up, but.
I mean, that's exactly what that's.
I know there was a very crazy
Deputy,
situation.
do you mind bringing up Mr. Robinson, please? Yeah.
I can let Mr. Robinson tell you about it. He really would like to do the PTI.
I would like to win the lottery.
I will, y'all want.
I would like more hair. I really want more hair. You know, it's not gonna happen. So.
And Judge, I have discussed with him, more than likely we'll get him this offer, so I can.
Well, we've done that before.
Yes,
We've
I
had
know,
other
I
people
know.
try to scare him too. It doesn't work.
And we're not on Zoom, right? Or we are?
We're always on Zoom.
So I had a message from Peter to leave, but I won't deliver it on Zoom. I'm sure he can
Felt the
imagine.
leaf that we love him. What's Peter doing today? Where's he at?
You know what? I thought he was gonna be up here, but I haven't seen him. He's doing his usual thing. Making messes.
Why on earth, after your case being 350 days old, you've taken off on us multiple times, and in December, We spoke about the offer that you had 2 hours of community service and a class for dismissal. Yet reset after reset, and then you just blow us off. So why would we reward you with letting you go to try to get this thing dismissed, Mr. Robinson?
You can answer the judge, yes, sir.
Your Honor, when I never came, I got a letter that says do not appear to court on December 5th. So I never spoke to anyone after being here in August. I never spoke to anyone, but I do have a job. I am a working member of this society.
You think that just because you don't have to appear for one setting, that the thing goes away? Poof, like a fart in the wind?
No one called me or contacted me, Your Honor, and I was unaware.
Then it is your responsibility to contact the lawyer. You are not Mr. King Robinson, where people are going to throw down a red carpet for you, sir. This is your case. It is your responsibility. They're not going to sit there and try to catch you. Oh, come on, Mr. Robinson, can you please come to court? No, it doesn't work like that. And you have had enough cases in the past to know how the justice system works. So why would we let you go? To me, you get one PR bond to make things right. I'm not down with giving you multiple PR bonds. I'm not. What do you do for a living?
Actual account manager.
How much money do you make a month?
I only retained 2,000 out of it.
You're telling me you make $50,000?
Sir,
How much do you make a month?
He brings in $2,000 a month, Your
2,000,
Honor,
yes.
before his expenses. His child support is approximately $495 a month plus $100 in back child support. So
7 kids, it's $500 a month? That can't be possible. Does the court know about your 7 kids, or do they only know about 1 kid? Because typically, child support for 1 kid is around $400 a month, not 7 kids.
Sir, Your Honor, I took a Zoom call with the Attorney General, and my wife was online, and that's what he ordered, sir.
What is the offer on this case now?
the prosecutor has offered a PTI of 90 days. It was originally a 45-day PTI
I'm
offer,
not resetting this case for 90 days.
or he has offered a time served, Your Honor.
So to get this thing dismissed, what did he have to do?
Originally, it was 45 days community service, and
I have here,
the state increased the, I'm sorry, it's now a 90-day PTI offer. Hold up on mine.
what do you want?
10 hours of community service and an effective decision-making class.
That's what it is. 10 hours of community service and an effective decision-making class?
Yeah, I increased hours and skip on.
Mr. Robinson, you have 1 week to get this thing done.
Sir.
And I'm gonna tell you now, you ever take off on me, I will make your bond $50,000.
Yes, sir.
Do you understand?
Yes, sir.
And if you don't have this done in a week, against my better judgment, I'm giving you the opportunity to get this thing
Yes, sir.
dismissed. You have 1 week. I don't care what your excuse is. I don't care if Jesus comes down and tells you to do something differently. If you're not back here in a week with everything done, you will get an immediate trial setting. And all offers off the table because I will not accept anything else.
Sir.
Do you understand?
Yes, Your Honor.
1 week. Okay.
Thank you, Judge.
Yes, sir.
Then, yeah. Okay, I'm sorry to keep you waiting. Thanks for being
No,
patient.
absolutely. You back up and running?
Yeah,
All
yeah.
right. Poaching on an off docket matter?
People want to see you. They do.
I appreciate
Really?
that. Yes,
Okay,
I appreciate that.
so who do you have?
Sterling Wiggins, Judge. I have the cause
Wiggins,
number.
that's right.
Yes.
So where is Mr. Wiggins?
He is in the pew, sir. With his
Come on,
mother.
Mr. Wiggins.
And just for some context, defendant missed an arraignment on 4/19. Transportation initially was the issue.
Council, hang on.
Sorry, I just need the cause number.
505-146.
That's it. Okay, tell me.
Yes, Judge. So initially, transportation was the issue for the missed court appearance on the arraignment date. However, between April 19th up until we were retained, which was last month, the family has undergone significant financial hardship. So much so that they are currently ongoing on the process for finding a new home to make a permanent residence. So for that reason, Judge, we are simply trying to reinstate the initial PR bond that he was given, or in the alternative, a bond amount not to exceed 2,000.
Hey, Victoria. Yeah, so just.
For Wiggins,
Yes.
when did we initially see him?
So his first appearance here.
I'm gonna make his bond contingent on one thing.
Yes, Your
Because I told him, and I told you, I did not want you to smoke weed. And I told you that I was going to test you in 30 days. And what did you do? You took off on me. That's what you did. I'm sending you now for a drug test. I want to see what, if anything, is in your system. And we'll go from there. Because that's what concerns me the most. Are you using? Because you know, since day one, the first day you got here, I told you, don't smoke weed, right?
Those notes
'Cause-
are for different.
Yeah, I didn't.
This is Wiggins, right? I'm having here that we spoke to him and told him not to smoke weed.
Yes, Judge, this is Wiggins, but I put the notes on a different. Wiggins had a PR bond back in April and didn't show up on that court date.
It was his first arrangement.
That was his first arraignment.
How many PR bonds has he gotten?
One, because his other cases were closed out. So this is his first arraignment on April that he felt to appear, so one time. I'm gonna go and update those.
Mr. Wiggins, have you ever played Monopoly? In Monopoly, you get what? A get out of jail free card, don't you? This is the only one that you're going to get from me. You ever flake on me again, I will put you over my head like a little child. And guess what's going to happen? I'm going to test you 31 days from today. You were on notice. Don't smoke weed. Do you understand? I'm bringing you back here 31 days. If I have found that you continue to smoke, and I don't care what your excuse is, I don't care if you're in a car with 15 people and they're all toking, or if you're fall down and there is a bong in your mouth because you fall down on it. You test positive in 31 days. You know what's going to happen, right? What's going to happen? Very good. That's right. Today, I will reinstate your bond. It's the only time I'm going to do it. From now on, I don't care what your excuses. I don't care who you have next to you. You ever flake out on me again, I will make your bond really, really high. And if you are so financially destitute as they say you are, you'll be stuck like Chuck in jail until this case is over with. And I'm going to tell you, it takes damn near 9 months just to get a 911 call. And you will sit there until all that happens. you understand? How old are you? You're 18. What do you do in life? Where? So you graduated from high school? Since January, this is your fourth case. If you truly want to go to school, what you're doing now is all wrong. Because when employers look you up, they're going to see all your criminal history. It don't matter if it's dismissed or not. They're still going to see it. Do you think they're going to want to give you a job? With your assault case now, the entire world is on notice that you have a trigger temper. What employer in their right mind is going to give a job to someone who has a hair trigger temper? Because they know they push your buttons, you're going to let loose on them. No employer wants that. The more criminal cases you pick up, the bigger hole you're digging. This is already 4 this year, and we're only 7 months in. What's going to happen next? So you best be on your best behavior. Otherwise, you'll stay with me. Do you understand? Who's with you? Mom? Is that Mom? Come on up. Who is the assault? Who's the complaining witness?
A prior significant other, no longer in the picture.
It was a dating relationship, Judge.
Are you Mom? Thank you so much for coming. I really appreciate you coming. It tells me a lot. This is his 4th case this year. And now he's facing a year in jail. He missed the first court date, so I issued a warrant and I put his bond at $2,500 because he missed court. He tells me he's going to start Lone Star, he's going to start college in the fall. I don't know if that's true or not. All I know is that the more cases he picks up, the harder his life's going to be. Your life is hard enough as it is now. All you're doing is repeatedly shooting yourself in the foot as it is. Does he live with you?
Yes, sir. We're in transition right now, so we stay in extended stay until I can find us another home.
Okay. We have services through the MAC that we can help you out with it, whatever you need. We have social services, if you'd mind looking into try to helping them
Absolutely,
with
Judge.
any kind of housing. We have services that will help you with whatever you need. All you have to do is ask and we can help you out. And I'm happy to do it with whatever you need. The only thing I want to do is make sure that he behaves himself while he's out on bond. So if you ever have any problems with him, if he mistreats you, doesn't follow your rules, just come back to me and tell me and I'll straighten him out for you. You know, but I'm at wit's end with Mr. Wiggins. I'm up to here, like my own kids, and I'm not going to stand for it anymore. You step off the line one more time, I will put you on my knee and I'm going to spank you with a ton of jail time, just like a little child. Do you understand, Mr. Wiggins? So, Mom, you need anything, just all you need to do is holler, and I'm here for you.
Yes, sir. Thank you, sir.
So the complaining witness is a significant other that they no longer have
No longer.
contact with.
Yeah.
Okay. So he's charged with assault of a family member, $4,000 fine. Not only that, this is the kind of case that can have severe ramifications where, you know, if he were to pick up another one, unless this thing were to be dismissed, if he picked up another one, he's looking at 2 to 10 in the penitentiary on a 3rd-degree felony. And you could potentially never own a gun or ammunition as a result as well. So there are really, really big consequences with this type of case. Do you understand? You are not to have any contact with the complaining witness in this case whatsoever for any reason. I also told him that I'm going to test him 31 days from today and that he better not smoke weed, because if he smokes weed and I test him, I'm going to put him in jail. I will revoke his bond. He's not allowed to smoke weed while he's on bond. No weapons as well. You are now on notice of everything that is expected of you. Do you understand? Are you working? So what are you doing to pass the time?
Ms. Phillips.
You need to find something to occupy your time, because when you have too much time on your hands, you become self-destructive. That is what is happening. Have you had a job since January? Do you have a driver's license? Do you have insurance? Is that right? Does he have? Okay, as long as you have both, then you can drive. When you have too much time, you become self-destructive. You need to find something to occupy your time. And I tell you, there's no better way that you can help your mom than getting a job, a full-time job, and helping her with money. I'm telling you, if you were to do that and help your mom, she would be over the moon with you. And you won't get in trouble because your time is occupied doing something productive. So that is now another condition. You must get a full-time job. Or if you have a part-time job, if you're in school. But I don't want you roaming around without nothing to do. Do you understand, Mr. Wiggins? So when you come back in 31 days, I want to see what you're doing with your life. You must have a job of some sort. No home health care. And they'll explain it to you if you don't know what I mean. You understand? Okay. So Tracy, you got all that? Okay. Mr. Wiggins, good luck to you. All I'm asking you to do is make me proud. I'm not asking you to do anything. I'm not asking you to split the atom here. All right? All right. Good luck.
Appreciate you, Judge.
Reinstate it now.
Yes.
Now knows what's expected.
Thank you, Judge. Maybe excuse you. Appreciate your conditions.
Thank you so much.
And if you need anything, just come back to me, okay? For sure. 2505 146. Oh, really? He doesn't want to do the week?
He's changed his mind. Yes. We would like to be done with this case today and not risk a
Ready?
trial. Mr. Robinson, come on up.
Judge, this person, Mr. Wiggins, wanted 2 weeks pending proof of the job and then 30 days?
No, this one, we're gonna do just 31 days. He comes back, we'll take a drug test and to see what he's done to get a job. Say 19.
Senior court file.
But I never wanted to hear another one.
Yes, ma'am. It is time certain.
It will.
Judge, were you able to sign this transfer order?
You filed it electronically?
Yes.
Yeah, I'll do it right now. Okay, done. All right, Mr. Robinson. You're charged with false report to a police officer. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. What is it, Melissa?
3 for 5.
3 days in jail.
Judge, I'm sorry, it's actually 180 days or 2,000. I believe it's a class B.
Oh, sorry.
Sorry, just to,
You're right.
sorry.
It's a class B. I don't know why. That's weird. All right, you've worked out an agreement. They're offering you 3 days in jail, credit for the 5 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. There's no buyer's remorse here, like Target, where you get tired of the conviction, you can return it because once you plead guilty, you are stuck with this. You give up the right to appeal, so you can never come back and try to change this, undo this, challenges. Are you sure you want to do this?
Yes.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You, like I said, you give up the right to appeal, so you can never come back and undo this. This is what you want to do. How do you plead to the offense? Or guilty or not guilty? I will find you guilty, sentence you to the agreement. Good luck to you, sir. I'll roll your court costs so you won't owe anything. Understand, from now on, you will be facing a minimum of 30 days in jail for any cases that you pick up. So be very careful. All right, good luck.
Thank you, Judge.
Thank you.
Wait, Mr. Robinson?
Pavel, let's talk about Ms. Johnson, if you don't mind. So,
You want me to approach Judge on the PC?
yeah, I get you. I mean, you're welcome to stay there. You don't have to get up, but so what we have here, I mean, are you ready? Did you read it?
Yes, Judge.
So we have a lady
Yes.
who's in a house, I guess just in bed with someone who's got felony warrants
In the garage, but yes.
in the garage.
Yeah, and they're both laying together and the drugs were found right by both of them. Neither of them took ownership, so we charged both of them because they both have care, custody, and control of the drugs without any ownership. Everyone gets charged in those kind of circumstances.
Whose house is?
So I would need to do some follow-up as to whose house it is, but I know they were in the garage of this house.
I mean, if
Okay.
it's her house, it's one thing, but
I guess from what I understand, the defendant articulated as the co-defendant's moms, but I don't have any way of checking that right now.
say that again. So she says it's the mom's?
It's the co-defendant's mom's house and they're in the garage.
Oh, the house. It's her house.
So it's their house.
Because I mean, that's like me going to your house, right? And I'm sleeping on your couch and just, there's a little weed over there. I'm just a guest. And cops bust in, they charge me with the weed. What?
I guess the argument is because they're in close proximity, since it's right by the bed, they both have care, custody, and control of the judge.
Yeah,
And
I'm not.
That's the definition of it, so.
Yeah, but I don't, if she'd claimed ownership, if it's her house, if there's something
Yeah,
a
but
little bit
if they-
more.
Requiring them to claim ownership for purposes of.
No, I'm
PCM,
not saying that
would
you
be-
have to, but I'm just saying, I just don't think it's enough. I mean, imagine I go to your house and it's the same thing, you know? So I'm crashing on your couch, just hanging out. I didn't know.
Oh, yeah, okay, so we did confirm the home belongs to both parents of the co-defendant. They're both listed as the owner of the house.
So the house belongs to,
The co-defendant's parents.
okay,
And the
I'm
co-defendant-
gonna find no PC for her.
Yes, sir.
Come up, Ms. Johnson. As the old adage goes, when you hang with dogs, you get fleas, right? Perception is reality. I'm going to find no probable cause in your case now. All right. That means I don't have jurisdiction over you. The state may well, in fact, indict this case at a later date. If that happens, a warrant will issue, but I'm going to find no probable cause in this case now. Just be careful who you spend time with and who you hang out with. You get my drift. All right, ma'am. Good luck. You're free to go.
Okay. I don't really have anything to say other than I disagree with the judge about perception being reality because they're two different words, and we wouldn't need two different words for the two different concepts if they weren't two different concepts. But I'll stop with that and introduce Magistrate Burton, who has some really interesting cases for us to watch. Let's check those out.
What's your name, sir?
Brandon Smith.
All right, calling case number 240-5833801. People said Michigan versus Brandon Smith. Appearances, please.
Ryan Murad, PA 3665 on behalf of Mr. Brandon Smith. We waive the formal reading. Mr. Smith stands mute. He's been advised of his rights.
Thank you, Judge Steve Vincent for the people, P71917.
Okay, waive formal court of not guilty plea on behalf of Mr. Smith, given the nature of the offense, lack of criminal history, ties, community, and objection to a personal bond.
I guess none at this time, Judge.
No objection.
$5,000 on a personal bond. Case is pending, Mr. Smith. You're not to possess any handguns, tasers, or other dangerous weapons. Is that clear?
And
Probable cause, July 26th, preliminary examination, August 1st, in front of Judge Giles. Have a good day.
Thank you, Your Honor.
Okay, Harold Williams, this is recalling case number 240-5833901. People said Michigan versus Harold Williams. Appearances, please.
Thanks, Magistrate Steve Vincent for the people.
And Ryan Murad, PA 3665 on behalf of Mr. Harold Williams. We waive the formal reading. Mr. Williams stands mute. He's been advised of his rights.
Court of not guilty plea on behalf of Mr. Williams. Argument is the bond.
Thank you, Magistrate. The people are going to be asking for a $15,000, 10% bond here. That's actually, Magistrate, the same bond that was applied for the last 3 cases this defendant was involved in regarding the same charges, and he was convicted on all of those cases. I've counted through the present that he's been convicted of 13 breaking and enterings, at least since the turn of the century, Judge. And we also have that felony escape from prison. And that's just a historical standpoint for criminal history. Then we have the allegations here where this defendant was captured.
Mr. Vincent, what was the dollar amount you asked for?
15,000, 10%. And Judge, the only reason why I asked for that was because it is identical to the last 3 cases that he's had regarding the same set of charges that he's been convicted on.
Okay. Mr. Rod?
Judge, on behalf of Mr. Williams, I'd argue that he's 66 years old, that he is a life resident here in the state of Michigan. He is not employed as he's relying on Social Security as his sole source of income. He has no pending matters. He's not on probation. He's not on parole. He's completed some college. And I would advise the court, he put us in contact with his daughter. He does have the family time. This is a non-assaultive case on its face. I'm looking at the habitual fourth offenders notice. the convictions appear to be from 1993, 2001, and 2011. I have nothing before me that tells me he's convicted of anything else. I'm sure I'll be corrected because this is all the information I have. But nonetheless, I think it's a lot different catching this case in 2024 than it was in the 90s and early 2000s. I think that there are programs now set in place to address some underlying issues if those are present. But nonetheless, it's a non-assaultive case. There's no capious history. I think personal bond is appropriate.
Judge Matt,
Yes.
his most recent conviction was in 2020. The three cases that I'm speaking about led to convictions with incident dates in 2017, 19, and 20. So he's had convictions, and with all due respect to defense counsel, because I think I do have a little bit more information than he does have 01 B&E and 04 home invasion, 5 B&E, 9 B&E, and these are all felonies, 11 B&E, 17 B&E, 19 B&E, 20 B&E. So, Judge, it's just a pattern. And it's just, and he continues.
What's the range, Mr. Vincent? What's the range? How many? It's over 10, 20, 30 years of these convictions? The range of them?
I have 9 since 04, but prior to the turn of the century, Judge, I have 5. But one of which included that felony escape from prison, but then he had multiple B&Es as well. So arguably, this is what he does for a living.
Okay, all right. Given the escape from prison, I deem he's a, what year was that conviction?
That was earlier on. That was in 90, Judge. Everything else stuff, yeah.
All right. In light of that conviction and a repeated pattern of breaking in, I find him a danger to the community and want to adopt a recommendation to Mr. Vincent, $15,000, 10% cash with the following conditions. No contact with Motor City Propane located in Livernois. He's able to post bond, GPS tether, house arrest. I assume this is an unaffordable bond.
Yes, Your Honor. May I make additional argument?
Sure.
I would just argue that if he hasn't been, if these are non-assaultive convictions and these are non-assaultive charges, how can we deem him a danger?
He's got repeated numerous breaking and entering a home invasion. And have you ever had your house broken into, Mr. Rod?
I have, Judge.
Okay, so have I. And given once, 2, 3 times or whatever, but a repeated pattern of breaking in and convictions over several years, a repeated pattern of convictions, I find him a danger to the community.
But Judge, breaking into a building is different than a home invasion charge.
He has been convicted of all those. Breaking into anybody's property, be it business, commercial, or home, repeatedly, he's a danger. And I'm sticking by that. You can make your argument Monday morning of bond redetermination. Your point is well taken, but for the safety of the community, and when he breaks into these past prior breaking into enter convictions, somebody could have been there or whatever, you put the owners in possible risk. And so for those possibly, I'm not saying it is, I'm saying possibly. And like I said, this is a repeated pattern of his, given his repeated past convictions. So I find him a danger to the community. It doesn't necessarily mean assaultive, but this repeated pattern of behavior is a danger to the community. Bond redetermination here Monday, July 22nd in front of Chief Judge McConaughey. Probable cause July 31st. Preliminary examination August 7th in front of Judge Sabri. Any questions regarding your bond and or court dates?
One last one, Your Honor, and I'm sorry, I'll leave it alone after this. My last question is, why do we think that a GPS tether and house confinement with personal would assure the safety of the community?
Why what?
Why would we think that a GPS tether and home confinement would not assure the safety?
Let me rephrase the question. Why do you think it is?
Because it would confine him to his home, and he can't leave his home. Breaking to anybody's home. That's the question.
That's your reason?
Absolutely. He can't leave. He's confined to his home.
Okay. Mr. Vincent persuaded me with his numerous list of convictions. I think he needs to, at least for the time being, the decision may be changed on Monday. That's not the first time it will happen. But I think he needs a little bit more than home confinement.
Just for this court's knowledge, when he was given 15,000, 10%, and all those cases were bound over, they were never changed. They were always kept through the conviction.
All right, thank you. Step aside, sir.
Thank you.
What's your name, sir?
All right, Mitch.
All right, Mr. Mincy, you got some traffic matters in which you failed to appear in court for, sir. As a result of your failure to appear, warrants for arrest were issued. The court's going to set aside these arrest warrants. Your personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney who can afford an attorney. One will be appointed on your behalf. Tickets are P956729, driver license suspended. Ticket P812627, driver license not valid. Ticket X3655471, no operator's license on person. Personal bond, no dollar amount on each of these misdemeanor tickets. Review date, August 16th, 9 a.m. in front of Judge Wagner. Now to your main matter, calling case number 240-583-4301. Please say the Michigan versus Renard Mincy. Appearances, please.
Lisa Coyle appearing on behalf of the people.
And Rad Marad, P83665, on behalf of Mr. Renard Mincy. We waive a formal reading. Mr. Mincy stands mute. He's been advised of his rights.
Court order not guilty plea on behalf of Mr. Mincy. What is your bond argument, Mrs. Coyle?
Your Honor, the people in this matter are requesting a $75,000 cash bond, tether house arrest. It looks like the address for the complaint is the place of the offense, and it gives a different address for the defendant. But they do have a dating relationship that's been on and off for 14 years. They at times have resided together. They do have a child that is 9 years old in common. This was an argument about the relationship in which the defendant allegedly grabbed her by the neck and strangled her. There was no loss of consciousness. He then got a handgun from his waistband, or I think from a pack, and he pointed at the complainant. She then began screaming, taking herself as well as her child. She calls the officer. The police come to the location. They see him. They tell him put his hands up. A handgun is then taken from his waistband. That handgun is registered to somebody else that he does not know in an address in Taylor. I also note in the APA's notes section that the defendant has been calling the complainant from jail. So I would be asking, I do not see any assaultive crimes in his background. I do see two juvenile felony offenses, a 2014 CCW and an ordinance misdemeanor in 2020, but nothing assaultive. But based on what the allegations here are, backed by the fact that they recovered a gun that was on the defendant that evening when they were coming to the scene, I believe that he is a danger to the complainant. This is his 9-year-old son that he was doing this in front of. I believe he may be a danger to his son as well. So for those reasons, Your Honor, the people are asking for that high cash bond, tether house arrest, if he does make that bond. And of course, no contact with him or the child at this point, Your Honor.
Okay,
I'm sorry,
clarification.
her name is Ms. Hudson.
Okay, point of clarification. They live in the same house or down the street from each other?
It looks like they have been together for approximately 14 years. I think they reside on and off together because it does say, but I noticed in the investigator's report, there are two different addresses. And it looks like her address, place of offense. So I would ask for no contact with her address.
Okay. All right. And you said $75,000 cash?
Yes.
Okay, Mr. Rod.
Your Honor, on behalf of Mr. Mincy, just some points of clarification. He doesn't reside in the city of Detroit or at that Pingree address. He resides in Highland Park with his girlfriend, who's not the complaining witness. He has children with his girlfriend. I believe the allegation is also that he shares a child with the complaining witness. The only prior I see is non-assaultive, as mentioned by the people. No pending matters. He's not on probation. He's not on parole. He got a good job at RCO Engineering. He works 8.5 hours a day. He supports a family size of 4. And there's a few things that I just want to point out that always draw my attention. When I see things.
One moment, Mr. Rob. What were his work hours?
He works from 12 p.m. to 8:30 p.m.
Okay, go ahead.
Additionally, Your Honor, there's allegations of strangulation and, and a neck, putting a hand around a neck. It doesn't appear, officers indicate in this report that no injuries were observed on the complaining witness. Their medical attention was refused. So we have a case with no injury story. And we ultimately have 2 parties who don't live together. My client has no problem not residing near that or not going near that street. He does have an alternative. He does have a residence in Highland Park where he lives at. I'd ask the court for personal bond. I mean, a GPS tether if you must, but Mr. Mincy understands to have no contact with this party, that address, and is maintaining his innocence when it comes to these allegations.
Does he have children with this complaining witness?
Yes, Your Honor.
In addition to the girlfriend he currently lives with in Highland Park, correct? Is that correct?
Correct, Judge.
Okay. Court haven't heard argument as to bond. The court, for the reasons stated by Mrs. Coyle, $75,000 cash surety. I find him a danger to the complaining witness. With the following conditions: not to possess any handguns, firearms, or other dangerous weapons, no contact with Shanique Hudson, no contact with the Pingree address where this alleged incident occurred, GPS tether, 10:30 p.m. to 10 a.m. curfew. I assume this is an unaffordable bond?
Yes, Your Honor.
Bond redetermination here Monday, July 22nd, 9 a.m. in front of Chief Judge McConaughey. Probable cause, July 26th. Preliminary examination, August 1st. Both in front of Judge King. Any questions regarding your bond and or court date, sir?
May I make additional argument, Your Honor?
Yes, you can.
I would ask the court, obviously the court's aware that the court rule is that we have to state why non-cash means wouldn't be sufficient. And I don't know why GPS tether home confinement on a high personal bond wouldn't assure the court that of community safety. Can the court elaborate on that point?
You said GPS tether house arrest or what?
Yeah,
I just want to make sure I heard you.
Yeah, that's what I was asking for. As to why GPS tether house arrest wouldn't be sufficient with personal.
Well, because he's working, I would not give him house arrest. But I do feel he needs some confinement. That's why I gave a cash bond. If they were to post that, I was going to give him a bond with a curfew. I was not going to give him house arrest. And so, but I think he needs to be confined in a more he doesn't need to be confined at home. He needs to be confined in jail, in my opinion, while this case is pending. Like I said, he's able to post bond. Like I said, he'll have a curfew and he can go to work. But I don't believe that the least restrictive, or lesser restrictive means you have argued for, articulated for, will do service and justice to this alleged complaining witness, given their relationship, given these alleged facts, which are very, very troubling. I want to make sure that they have little to no contact, if at all, particularly in light of the fact when Mrs. Cole indicated that he's constantly, allegedly, calling her from the jail. So I just want to make sure they have no contact and they're far apart as possible. If he's out, house arrest, I just got concerned he may violate that, cut tether, go over to the house or whatever. I just want to make sure there's little no chance of that.
Can I say something?
Sure, we're gonna get another shot at this in 2 days. I don't want you to make any statements now, okay?
All right, any questions regarding your bond and or court dates, Mr. Mincy?
Yeah, I'm gonna tell you for a fact, she lying on me. I never put my hands on her.
No, Mr. Mincy, I know, we know, but we don't, this isn't the time for that, trust me. They're not even hearing it. You gotta wait a couple more
Step
days.
aside, sir.
And you can take
Step
it over.
aside. Step aside. Step aside. All right, last case of the day. Let's make it count.
I had a court date this morning,
Mr.
and I had no charges against me. No charges against me, and I've been here 6 days. Now, what's going on now?
What's your name?
My name is Mr. Ditto, D-I-T-T-O.
All right, sir, you got some traffic. You have some traffic matters. Listen, you have some traffic matters in which you failed to. You have some traffic matters in which you failed to appear.
I don't own a car, I don't drive.
At least I'm not the only one today. I mean, that makes me feel a little better.
Well, look what company you're keeping with, Mr. Vincent.
That's a very good point. I just thought of you. You know what? Let me strike everything I just said.
Okay.
Vincent is lucky to be in this company. I want you to know that, Your Honor. Miss Coyle is, Miss Douglas are extreme.
All right, sir. Sir, I just want you to listen. You have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside those arrest warrants, give you a personal bond, and issue these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and/or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. Can't afford an attorney. One will be appointed on your behalf. The tickets are P910332. Driver's license never required. No insurance misdemeanor. Driving a registered motor vehicle. Ticket P909096. Improper plates. Ticket 1848940212223. Driving a registered motor vehicle, driver's license never required, improper plates. In each of these misdemeanor matters, sir, you're in a personal bond, no dollar amount, pretrial August 19th in front of Judge Sherman. Is that clear? All right, on to your other matter. Case number 240-456-0701. Houston, Michigan versus Ditto. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Ryan Murad, on behalf of Mr. Dimitri Ditto. We waive the formal reading. Mr. Ditto stands mute. He's been advised of his rights.
All right, court order not guilty plea on behalf of your client. Argument of the bond.
Your Honor, I see no criminal history for Mr. Ditto.
I don't even have a car, I don't drive, so how could I have a ticket or anything? I'm catching buses.
May I, Ms. Quayle? Oh,
Okay,
Judge,
hold on.
Put them in
Hold on. Okay, go ahead, counsels.
Thank you. I see Mr. Ditto has no criminal history. He is 63 years old. This is a refusal to. That's what I said, 63. All right. And so.
She said 53, I'm 63 years old.
Go ahead, Mrs.
Thank
Coyle.
you. I'll finish my argument. I see he's 63, has no criminal history. This is a refusal for fingerprints, Your Honor. I'm just looking for a $25,000 personal bond, but a condition of release is that he be fingerprinted. Apparently, when he was arrested for an MDP, he refused, and that was on the 17th. He refused to be fingerprinted on the 17th and the 18th. So no objection to a high personal bond with the condition that he is fingerprinted before he is released.
Mr. Murad?
No objection to a personal bond, Your Honor. He indicates that he's also a Marine Corps veteran with no priors. This is a 90-day presumption against probation or jail.
Okay, I'm gonna give him $11,000 a personal bond upon being fingerprinted. Okay, I'm afraid to ask you to unmute. Unmute.
What do you say?
I said, have a good day. Pre-trial, August 29th.
The Judge Bryant, Your Honor?
Judge Bryant.
Thank you.
All right, everybody have a good weekend.
Everyone have a nice weekend.
All right, Magistrate, take care. Thank you.
Been in 2 wars.
Bye.
Thank you, Your Honor. Have a good weekend, everyone. Lady Clerk.
All right. It's that time in the show when I promised everybody I had a little bit of announcement, and I do have a little bit of announcement. We are moving our way into the Judge Manning segment of the show today, but before we get started with the Manning segment, I do want to make this little announcement that I am planning to start doing a regular Manning live stream on Mondays. Not this coming Monday, but the following will be the first one. And as we go into our Manning segment today, I'd like to show you a little trailer of the opening of the brand new Manning show. Go.
You don't need to tell your mother what I said. Get back on this screen. Turn your camera on now! Send them out of the room! Send those 2 girls out of that room! Now! Don't say a word, just send them out of the room. Oh, and go ahead and put yourself on mute now. Well, y'all must have missed everything that Miss Phillips and her 2 daughters said, and I'm just sitting here, let's see, I'm looking through the pre-trial, Let me see if Mr. Tannen put it in here. If her and her daughter was going to have a conversation on Zoom without it on mute. Nope, wasn't on here. Trayvon Jackson. Wait, no, there you go. All right, let's see. It's position 2, 24 PI 001347, 144 days without indictment. $7,500 good bond as of February the 26th, 2024 on burglary in the 1st degree.
No prior arrest.
All right, go ahead, Mr. Rogowski.
Your Honor, I represent Mr. Cortez Rucker.
Oh, okay. I'm sorry, Mr. Cazzoli, not Rogowski.
Thank you, Your Honor. It's it's those European names. All right, Your Honor. My apologies. Mr. Muhammad.
We need to get your name on Monsters Inc. too, Mr. Cazzoli.
Yes, Your Honor. Mr. Muhammad is 72 years old. He is residentially challenged. He's been living in Georgia since 2018.
You know what, Mr. Jackson?
Oh, I'm sorry, Your Honor. Oh, I think I heard you say Mr. Muhammad before I heard my name. Okay.
Oh, sorry. Yeah, I said Cortez. That was like I saw Mr. Jackson's.
There we go, Your Honor. Mr. Jackson is 19 years old. He has a good address at Valdosta, Georgia, 31602. Lives there with his grandmother. Your Honor, he has been living in Georgia his entire life. He is a high school graduate from Brooks County High. He played and also played football at St. Mary of the Woods College as well. He has 2 children. Your Honor, his bond is currently $7,500, and he has been incarcerated since February. Your Honor, this is a single burglary charge, first ever offense, no history. We're asking for his bond to be reduced to $1,000.
Thank you, Your Honor. The state would ask for $6,000 for the residential burglary.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 3443 Villa Circle Southeast in the city of, I think it's South Fulton. Let's see. Stay out of Fulton County. The only reason you come back to Fulton County, sir, is court or to see your lawyer. Court or to see your lawyer. And no further contact with Tamara, Tamara Knight, Knight, $5,000 good bond. Best of luck to you, sir.
And Your Honor, do we know if the state has made successful contact with the alleged victim in the case?
Ms. Rhodes,
Left a message. I'm sorry. We have left a message.
oh, okay. Left a message, Mr. Kazoli.
Okay, thank you, Your Honor. Mr. Jackson, so that's $5,000, sir. You can probably go through a bonding company if you have about 500 to 600. If not, I'll come to visit you in about 2 weeks, okay?
All right, you can leave the booth, sir. All right, now, Cortez Rucker. Nod your head if you're Cortez Rucker. All right, there we go. Position 8, 24 PI 002 695 169 days without indictment. This one was bound over from state court, and I did not see a bond on battery family violence. Wow.
Whoops, talking, but not on. Hold in Jonesboro for probation violation 8923, 15 cycles in Georgia. 2 in Alabama. There's a fugitive from justice. Open case 22 CP 206 224 for battery family violence felony. Ag assault 2017. Battery probation false imprisonment terror. 1/13/21, 2 years confinement, 8 years probation. Nothing further.
All right, go ahead, Mr. Rogowski.
Yes, Your Honor. Come before you is Mr. Cortez Rucker. He is 29 years of age. The address he would be residing upon release is, Your Honor, he's been a resident of the Metro Atlanta area for his entire life. Prior to being incarcerated, he was doing distribution work and working at a barbecue place as well. He's the breadwinner of his family and had been doing both of those jobs for about 8 months since 2023. He made it to the 11th grade in school. His whole family also resides here, so he has significant ties here. He also had a son that was very recently born within the past month as well. And Your Honor, we would be asking in this case, he's been in for all of that time, as you had heard, over 160 days at this point. We would be asking for $1,000 bond. And if I am not mistaken, the bond that I do see that is in Odyssey right now on the jailing screen is set at $3,000. And so we had a preliminary hearing on this case. There was a little bit of confusion moving it from state court to Superior, which I think explains the delay in the whole process here for the 160 days. But that being said, he did have to be there for that entire time. He currently, to my understanding, like I said, and I could be wrong, does have that $3,000 bond, but we would just be asking for that to be lowered to $1,000, Your Honor. Thank you.
And I also saw that $3,000 bond as well in the jail manager screen in Odyssey. And we have spoken with the victim, and he did say that she gave birth to the defendant's child. She also said that she needs support from the defendant. We're going to ask for a $2,000 bond with conditions that he support his child or children, and that he have no violent contact with the victim in this case, and that he consume no alcohol, possess no drugs or weapons.
Right, is that the incident location, the Old National? That 5401 Old National Highway, is that the incident location too? Is that where he lives, Mr. Rogowski?
No, he would be residing with his mother upon release.
Okay. All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further violent contact with Brittany Cousin, Cousin. Stay away from 5401 Old National Highway. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. let's see. Must support your child financially. I think the minimum for one child is at least $100 a month. That's the absolute statutory minimum. So we'll do a $2,000 good bond. Best of luck to you, sir.
Oh, something just popped up.
Reese, Reese too. Okay, who's that?
Reese.
Andre Mohammed. All right, it's number 3, Bostic, 24 PI 001361, 144 days without indictment. There is a $2,500 split bond for terroristic threats and acts and 3 counts of felony obstruction, but they were misdemeanor, but now they're upgraded to felony at the prelim. Pre-trial.
92 cycles, Illinois, history of city ordinance, misdemeanor assault. There's an aggravated battery on a government official in 06. In Georgia, there's 3 cycles, old simple battery, nothing further.
All right, go ahead, Mr. Cazzoli.
Thank you, Your Honor. Mr. Muhammad is 72 years old. He is residentially challenged, but he's been living in the state of Georgia since 2018. Your Honor, how many cycles did Madam Pretrial say?
92.
Okay.
In Illinois.
Oh, okay. How many were in Georgia, ma'am?
3.
Okay, thank you. Your Honor, so while he did have a large number of cycles, he only has 3 cycles total in Georgia. So we are asking for a reduction in his bond. I don't see how these obstruction charges are being treated jail side. It doesn't look like they've appeared there. But I know that at least the stated intent of Judge Brooks was to have the UJR stay, and it was just a $2,500 bond on the terroristic threats. Is your interpretation as well, Your Honor?
Well, I don't know, because she moved him from a misdemeanor to a felony.
She did, but this was also an opportunity for us to argue bond. So so the bond argument was asking for the bond to remain the same functionally. So at the time. So we are asking for a reduction now, Your Honor, of $2,500 down to $1,000 for the terroristic threats charge.
All right, go ahead, Mr. Malkin.
All right. The last time we spoke to the victim was opposed to bond. The victim said that they're afraid and fearful of the defendant. The defendant threatened to kill the victim, and the whole incident took place in front of the victim's 5-year-old child. And so we're asking that the bond remain the same, that the defendant appears that the defendant poses a significant risk of danger and intimidation to the victim. And so we'd ask that it stay the same. And if we are addressing bond on the 3 obstructions, we would ask for $5,000 each on those.
All right, is he going to live in Fulton County?
Mr. Muhammad, are you planning to stay in Fulton County, sir? You just put a thumbs up.
Thumbs up or thumbs down?
Thumbs up.
Thumbs up or
sir?
thumbs down?
Fulton County, yes or no? You don't know right now? All right, we can't hear you, so you're on mute. So you just have to communicate with your thumbs.
I need a thumbs up or a thumbs down.
We can't hear you.
All right, let's see. It's no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 250 Park Avenue West. No further contact with Alexis Dutton, Dunton. Also, let's see. Stay away from the World Congress Center. So do 2,000, 3,000, 3,000, 3,000. Best of luck to you, sir.
Your Honor, sorry, are you raising the bonds on the willful obstructions? Or is it your interpretation that these are in no bond status? Because
I bet they were in no bond. It was mine that they were in no bond status when I looked at it once she bumped them up to a felony, because then they're different charges.
Your Honor, if I can just take a second just to double check, because I know that from what I remember in my conversation with Judge Brooks, the whole argument was instead of reducing the total amount, which would have been $2,500, we were keeping it the same. That was the reduction. Here, sorry, I'm on the wrong page. Let me. I'm sorry, Your Honor. If I could just take one moment.
Okay, I'm still trying to get the Zoom controller to work. and I'm not gonna keep everybody on here forever, so, I mean, this may be our next Thursday calendar.
Yeah.
Okay, yeah, because I see she did not add a new bond order, and I suppose that would have been required here. But I guess just as an agent of the court, Your Honor, I can tell you that my understanding of Judge Brooks's intent was to keep those as UJRs. The only reason that they were elevated whatsoever is that it was already taken into account, Your Honor, that there was a struggle during the arrest. The alleged conduct is that during the struggle, he was lashing out. That was the change that shifted it from a misdemeanor to a felony. There was not a significant amount of conduct extra that was alleged here. And I know on jail side, it just indicates the terroristic threats and just shows the other charges as dismissed. So the total still being 2,500. I believe it is within your discretion, Your Honor. So we understand if that's your decision. But again, I just wanted to provide that context.
I got you, Mr. Malcolm, what's your?
Well, looking at the Ayala factors and that it is within Your Honor's discretion, with 92 cycles, it appears that there's a very significant likelihood to reoffend and danger to the community, as well as risk of danger and intimidation to the victim in this case. So we would ask that the $11,000 bond be the bond amount.
Yeah, I'm going to leave it the same, Mr. Cazzoli, just because of, yes, he does have 93 cycles and he doesn't know where he's going to live. So
I'm sorry, by the same, what is the total there? That
was 3,000 on each.
Okay.
Felony obstruction.
Thank you, Your Honor.
All right, let's see. What about Richard Stiles? All right, there we go. Position 10, Mr. Dobbs, we got 24 PI 002628, 95 days without indictment. There's a $100,000 good bond as of May the 7th for 4 counts of aggravated assault and 1 count of possession of hydrocodone. Wow.
5 cycles, no felonies, a disorderly conduct, 3 counts in 2016, took a first offender on ag assault in 2007, nothing further.
All right, go ahead, Mr. Dobbs.
Thank you, Judge. Mr. Stiles, as stated by the court, has been in jail for 95 days. He is 39 years old. He has 1 child who lives locally. If released, he would reside at his mother's address, which is in at Atlanta 30349. As stated, he's a lifelong resident of the Atlanta area. At the time of his arrest, he was working a warehouse job for UPS. Upon his release, though, he will either be working at Pascal's, a restaurant where he's previously worked, and he knows that he can go back, or a hotel which is by Pascal's. Judge, because he's been unindicted and in jail for 95 days, that's 95 days for which he has not been able to assert defenses, only a preliminary hearing and bond. Because of his strong ties to the area, because he took 1 first offender with no other felony convictions, and mainly because he has no FTAs, Judge, I would posit that a reduction to $50,000, $50,000 aggregate is appropriate. The main purpose of a bond is, of course, not meant to be punitive. We all know that. The purpose of bond is to ensure one's presence at a court. That's the main purpose. And with no FTAs and the strong ties, there's no question that he is not a flight risk. $50,000, while it is a large reduction, is still a substantial bond, especially for someone to have to pay, especially when they're legally innocent of all accusations. So we are asking for a reduction to $50,000 in the aggregate. Thank you.
All right, what says the state?
Judge, the state would highly object to any type of reduction in the bond in this case. In fact, because this is a motion for reconsideration, I would implore the court to raise the bond in this case. The facts of this warrant states that Mr. Stiles was in the car with his girlfriend, Vanessa Higgins. They got into a verbal altercation, which then led to a physical altercation, where Mr. Stiles dragged the victim out of the car and left her on the side of the road. After the victim called the police to report the crime, Mr. Stiles appeared at the victim's home, waited until her and 3 other friends opened the front door, and proceeded to shoot multiple rounds from an AR-15 from his vehicle into the home and into the doorway. all of the victims reported feeling as if they were in harm of serious danger or death. Mr. Styles has a dangerous history. I understand Mr. Dobbs saying that he took a first offender, but it was a first offender to an aggravated assault with intent to rob, another robbery, and a firearm during the commission of a felony. For that reason, Judge, we do believe that Mr. Styles is an extreme danger to the community as he shot in a neighborhood from across the street into a home. We say that he's a danger to the victim as he does have strong ties to this victim being his girlfriend and her friends. And he is likely to reoffend since his history seems to be a pattern of behavior that he continues to do. I believe we have had victim contact in this case, and Ms. Jones may be able to speak more to that, but at the very least, Judge, we would request that each one of these aggravated assaults stay at $25,000, which is more than reasonable to ensure that Mr. Styles appears back in court. Again, I understand the defense's argument about bond, but he does have a bond. This isn't an argument of no bond. This is just an argument to modify it, and I don't believe that would be reasonable under these conditions.
All right, go ahead, Ms. Jones.
Your Honor, I did have the opportunity to speak with Vanessa Higgins, and she stated that she's afraid for her life. She stated that she does not want to have any contact with him, and she stated that he had fought her before, and right now there's a TPO against him. She's just asking that he remain detained for the safety of the community and for the safety of herself.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 3065. It's CADIZ Circle in City of South Fulton. If it's available, you're going to have an ankle monitor paid for by the county with a 24-hour curfew. Even if that's not available, you're still going to have the 24-hour curfew. You can only use your house to see your lawyer, court, and medical appointments. No further contact with Vanessa Higgins, Higgins, Sheena, Sheena, Brantley Wood, Brantley Wood, Wood, Anna Brantley Wood, Loretta Brantley Wood, and no further contact with Jameen Watley. Let's see if I got them all there. Yeah. And Jamin Watley, Whatley. So you'll have that 24-hour curfew, sir. So I'm gonna leave the ag assaults at 25,000 and actually put 2,000 on the possession of hydrocodone. Best of luck to you, sir.
Judge,
Yes.
Can this case please go in your email?
Go in my
If that's
email.
still going on?
Yeah. Oh, yes, sir. Yeah, you should have got one the other night if you were here. Yeah, if you're here, you get an email.
Okay, thank you. I appreciate that. May I please be excused?
Absolutely. Have a good one.
Thank you.
Your Honor, was Betty Hunt taken off the list today?
Yeah, she was indicted. Do you need that?
Thank you so much.
Okay, so you want the, I don't have the indictment number. Betty
I
Hunt
do.
was indicted.
You want it, Megan?
Dylan Harris.
I'm okay. Thank you, though.
Oh, Miss Beck. I thought that was Megan.
Yeah.
Dylan Harris and Betty Hunt.
All right. Thank you so much. May I be excused?
Bostic.
This time
Can
she
Megan
can.
leave?
This time.
Have a good night.
Bye.
Have a good one, Miss Beck.
You
All
too.
right. Karnovsky Franklin. All right, there we go. Ms. Kennebrew, we got position 11, 24 PI 002705, 91 days without indictment, no bond as of 4/18. Count 2 is dismissed, so it's just kidnapping and battery. Wow.
Anthony Norman.
No, it's Franklin. Position 11. Yeah.
Franklin. Open case 22 SC 186667, aggravated assault with a deadly weapon, 2 counts, terror, firearm during, firearm by, another count of terror, carnicel, judicial hold, Minnesota 16 cycles, 2015 terror, ag assault, robbery, 2015 assault, domestic assault, 2016, financial transaction, 2000, 1 arrested in Alabama, 5 in Georgia, FTA in 23, probation, ag assault in 21, 8 months confinement, 4 years, 4 months probation, a very old terroristic threats and purchase, manufacturing, and sale. Nothing further.
All right, go ahead, Ms. Kennebrew.
Yes, Your Honor. Seeing as it's the 91st day, Mr. Franklin is legally entitled to a bond on today. He is 51 years of age. He has a valid address in Metro Atlanta where he has resided, and he currently resides with himself as well as his wife. He has been in Georgia for over 12 years. Prior to being arrested, he was working at a mobile detailing business, and he had been working there for over 6 years. He did complete his GED. He also did complete his associate's degree at Minneapolis Technical College, and he got a degree in business administration there. He is the proud father of 4 children whom he loves and wants to get back to. We would just be requesting that the bond does not exceed $10,000 total for both charges, Your Honor.
All right, go ahead, Ms. Jackson.
Judge, none of the pretrial summary of Mr. Franklin's criminal history was quite egregious at best. He has an extremely violent history, extreme likelihood to reoffend, almost in the exact manner that we're looking at on the calendar today. This warrant says that Mr. Franklin got into an altercation with a female after soliciting some type of sexual activity from her. She was accused of stealing something from him, so he chased her down to a gas station, went inside in front of multiple witnesses, picked her up and carried her to the car. And essentially that's how he picked up the kidnapping charge. Judge, Mr. Franklin is dangerous. And he's a danger to the community, a danger to the victim. And based off his extremely likely, or his extremely violent history, he's extremely likely to reoffend. The state will be requesting a bond of $150,000 on the kidnapping and $20,000 on the battery.
And if I may, Your Honor, we did have a preliminary hearing for Mr. Franklin, and when we spoke with the officer did say that there weren't witnesses that he could provide that saw Mr. Franklin pick up the alleged victim and bring her back. The officer testified under oath to this. We would just be requesting that the bond represents the charges that are before us. We didn't hear any FTAs from pre-trial. He does have community ties. He does not know this alleged victim. The alleged victim was actually a prostitute, and so she was selling herself to people for sexual favors. So we would just again ask that the court takes that into consideration when you are setting the bond, Your Honor.
All right, so he's going to live in Fulton County?
That is correct.
All right, so we got no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with your alleged co-defendant, Jeffrey Hardy, Hardy. No further contact with Jessica, last name Brooks, Brooks. Stay away from 3 Joseph E. Lowry Boulevard Northwest. That's at Texaco, so stay away from there. All right, I already said no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. If it's available, you'll have an ankle monitor paid for by the county with a 24-hour curfew. If it's not available, you still have that 24-hour curfew. The only reason you could leave your house is court, see your lawyer, and seek medical attention. Court, see your lawyer, and seek medical attention. $50,000 and $20,000. Best of luck to you, sir.
Thank you, Your Honor. And that
Thank you, Ms. Kennebrew.
Excused.
Bostic, can Ms. Kennebrew go? No, that one has to stay.
You all have a great evening.
You too. So
Have a
let's
good
see.
evening.
All right, Mr. Duffy. Mr. Duffy, is that you? Wave your hand if you're Mr. Duffy.
No, he thought his hearing was canceled, so I was going to get him.
Oh, gotta go get him.
There he is.
All right, let's see.
By south, I think.
Yeah, position 9. So it's 24 PI 002980 Denorius Duffy, 102 days without indictment. Right now, there is a $55,000 good bond as of May 24th. Armed robbery, ag assault, and possession of a firearm during the commission of an attempt to commit certain felonies. Pre-trial. Go ahead, Bostic. Okay. The other cases that are holding him in jail. He's on probation for street gang tools, entering auto criminal damage to property. Sentenced in 2020, 3 years confinement, 2 years probation. He has 1, 2, 3, 4, 5, 6, 7, 8, 9 cases. 481 is tools. 466 is theft by taking. I already said 466. 338 is theft by taking. 377 is theft by taking. 339 is theft by taking. 434 O is theft by taking, 341 is theft by taking. The indicted case, the Edwards is street gangs, 3 counts, theft by receiving tools, firearm by. I think that's all of them.
All
So
right,
his
go ahead,
only
Mr. Melnick.
conviction is the probation.
All
Nothing
right,
further.
go ahead, Mr. Melnick.
So Judge, as you said, 102 days in jail with no bond. He is 22 years of age. He's not quite 23 yet. He does have gainful employment waiting for him upon his release from custody. He has multiple family members that live in the metropolitan Atlanta area, very strong ties to the community. The current bond is set, I believe, is this the one that's set at 55,000? Am I right about that?
It's 55.
Okay. So Judge, with the amount of time that has passed since he's been arrested with no indictment for these charges, I would ask that you cut the bond in half and give him a $27,000 bond.
All right, any contact, Ms. Dorsey Jones, with the victim, Jamal Aaron?
Yes, Your Honor, I did speak with Mr. Jamal Aaron, and he stated that he opposed the bond at this time. He stated that she was a menace to society, and he just felt like she needed to be released for the safety of the community and for the safety of herself.
All right, go ahead, Ms. Jackson, sorry.
No problem, Judge. Judge, unfortunately, this case essentially speaks for itself. You guys just sat and listed out 9 open cases with Mr. Duffy, all with very similar charges that are on the calendar today. The facts of this case from the warrant say that Mr. Duffy cut a vehicle off, jumped out, pointed a long gun, and demanded that the victim give his chain and his watch, or else he will be killed. Mr. Duffy is an extreme danger to this community. He is 22 years old. He's already picked up a 2020 entering auto conviction. He's been a confirmed gang member in 2020. During that time, he became a flight risk when he fled and eluded from the officers, which did result in a conviction. He's got 9 additional open cases, all similar to the one on this calendar today. In fact, one would argue that the cases prior to this became increasingly more violent all the way up until this point. For that reason, Judge, we do believe that Mr. Duffy is a danger to the victim because the victim has stated that he believes he is so. Based off his history of fleeing and eluding, he's a flight risk. And based off the fact that he has 9 open unindicted cases, including this one, he's likely to reoffend. For that reason, Judge, $30,000 on an armed robbery is more than reasonable. $20,000 on an aggravated assault is more than reasonable. $5,000 on a firearm during the commission of a felony, particularly since this should have been also charged as a firearm by a convicted felon. Judge, we would state that this is a reasonable bond.
All right, so no drugs unless prescribed, no alcohol, no weapons, no replicas.
Judge, can I just, I know I'm just kind of putting a cherry on top of all this. I can't see Mr. Duffy right now. Could he just make some noise so the judge can see him?
I put him back on mute, Ms. Rockwell, but if you
can you
change
raise
the
your hand, Mr. Duffy? I just want the court to know that, and I know the facts aren't important, and Madam DA kind of did go through some facts. I know they're not important, but I do want the court to know the police report talks about the individual, the bad guy, was light-skinned and he had a mask on. That's all I'm saying. So, maybe that's the holdup on the indictment, that they might be looking at him right now, thinking, well, maybe this guy isn't light-skinned and he had a mask on. That's all I'm saying, Judge. I just want to throw that little cherry in on top. So,
right.
but
Mr.
thank
Melnick,
you, Judge.
Mr. Melnick, is he going to live in Fulton County?
That is his current address, Judge.
But it's not the Early Street, right? So no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 3090 Early Street Northwest. No further contact with Jamal, Jamal, Aaron, Aaron. Stay away from the Buckhead Saloon. You have an ankle monitor with a 24-hour curfew, court, lawyer, and medical, and that's paid for by you. Let's see. Make sure that Oh, and stay away from EAN Holdings. E as in Edward, A as in Adam, N is November Holdings. Since I modified his condition, stuff like that, I'm only going to reduce a little. 29, 19, and 5. 29,000, 19,000, 5,000. Best of luck.
Judge, where's EAN Holdings? Isn't that Enterprise? Could
Well,
you
it
tell
says
me
in the
where
warrant,
they are?
EAN Holdings, it's where the alleged stolen car was from.
That's a rental car. I've been trying to pay some restitution to EAN Holdings for about 3 years now. So if y'all can figure out where that is, y'all let me know.
Maybe it's in that, yeah, maybe it's in that, there's been a, I bet, yeah, let me see. Because it's been in a lot of them, so I don't know what it is.
It's a rental
what-
company. That's who owns all the rental cars.
Oh, okay.
EAN Holdings.
All right.
Thank you, Judge.
All
I'm
right,
gonna
thank-
stand down. Thank you
Mr.
so
Rockwell.
much.
Thank you,
Judge.
Mr. Melnick.
Thank you.
Mr.
Yeah.
Duffy, you could leave the booth. Anything else from anybody?
No, quickest day ever.
That's it. So yeah, in a couple of weeks, 7 p.m. Central Standard Time on Monday nights. Gonna be Manic Monday with Judge Manning every Monday on my channel. We're gonna do it live. We're gonna do it with a chat. We're gonna have fun. We're gonna comment about what we see. It's basically the concept here is I'm gonna gather up, you know, some of the best clips from the previous week, and we're all just gonna watch them that Monday. So that's the general idea. You know, I like Fulton County specifically because of that whole backlog, and Judge Manning is one of many great judges. I actually follow a few different judges in Fulton County. They all have kind of the same drawback when it comes to, you know, the format of their dockets and, you know, kind of the videos that I make because they're so fast paced. So yeah, we're gonna dig into some Fulton County. I love my Georgia cases. I love Judge Manning. I've been lamenting the fact that I have not had hardly any Judge Manning on my channel. So now that I'm at, like, you know, I think I'm getting close to 40,000 subscribers now. I'm adding a new one, and I'm considering possibly, maybe, at 50,000 subscribers, just think about it. Freaky Friday with Fleischer? Anybody? Yeah, just think about it. I think it's an idea. But as far as ideas go, you know, we'll see. 50,000 subscribers, though. That's 10,000 subscribers away. Statistically speaking, that should be around October. So we'll be keeping an eye on that. I may actually just decide that I'm having a fun enough time doing it that I'll just start doing it before I hit 50K anyway, because I love Judge Fleischer, and why not? Right? Just sounds fun. Freaky Friday with Judge Fleischer. I like it. Stay tuned. Colin's coming up next. He should be getting his stream started right now if he's been reading his DMs. He's already hard at it, getting that stuff spun up. I'm going to go ahead and click this button, which is going to take me to my end screen. And I'm going to do this little number. Just going to raise the volume on the end music. And I'm going to say, thank you all for coming out. I had a great time. Great cases. We'll see you next time. We're still doing this every Saturday, 11 a.m. But in 2 weeks, I'll see you Monday at 7 p.m. Central Standard Time for Manic Monday with Judge Manning. And next week, I'll see you right here for the weekend review from the Court Gallery. Live. Love you, people. See you next time.